Hi, I'm Shan Wu with a Under Color of Law hot take on what is it like inside Jim Jordan's select subcommittee on the weaponization of the federal government. So, first of all, it's the usual Republican projection where they are the ones weaponizing, obviously. So holding that aside, I have prepared a lot of people for congressional testimony, clients, DOJ officials, but this was the first time I was actually testifying, so I'm sitting in the hot seat in the witness chair. So let me tell you what it's like when this gets set up. So in a hearing like this, which was a select subcommittee, the members of Congress have a time limit, 5 minutes. And so what they're trying to do is to kind of ask long-winded questions. We'll let you hear some in a moment. And they want the witnesses to supply testimony. So unlike a trial setting, this is really pure cross-examination questions because they want to ask leading questions trying to get their points in. And they only have 5 minutes to do it. So when you sit up there, they have a little timer in front of you so you can watch the clock ticking down. And the sort of game for the witness is when the other side, whatever side is not friendly to your point of view, is asking questions, you're watching that clock to let them run out the time, right? Because they're going to have less time to ask questions and make their points. On the other hand, if it's your side, in my case, when the Democrats were questioning me because I was invited to appear as a witness for the minority, the Democrats, you kind of don't want to have long-winded answers because you want them to be able to get through their points relatively quickly. So that's the setup, and it's kind of fun, actually, for a lawyer because I understand cross-examination. And I'll let you listen to one exchange I had with a Republican representative, and take a listen, and I'll give you my take on it.
Is there a legitimate federal government interest in preventing that where it occurs?
Well, there's some jurisdictional limits on what the federal government can do there. I mean, if it's a state trial, they'd have to come in after the fact to examine whether there's been some...
Well, let me ask you this way. Was there a legitimate federal interest when Congress acted, as we just made reference to, in the post-Civil War Civil Rights Acts?
Yes, those legislative...
And they were designed to prevent that kind of misuse, right?
I don't know that they were designed specifically at the court system misuse, but I think they were designed to correct injustices.
You don't think they were designed to correct misuses and abuses of the court system, the state court system?
No, that's not what I said. It includes
so you
that.
Do, you would agree with me that they were designed for that very purpose,
not
right, sir?
Only for that purpose.
I certainly agree. It wasn't only for that purpose, but it was included.
So you can hear there that the representative doesn't really like the distinctions that I'm making. He's trying to correct me, but I was kind of pleased because at the last moment I had to get him to agree with my formulation of my answer. But he's trying to fight me to get me to talk like him, talking over me, trying to say, well, that is what you said. But like any good witness who's listening carefully, you want to correct them when they're trying to basically distort what your answer is. This next exchange with the same representative is a good example of the cross-exam leading type of question that is very obviously what he's doing. So take a listen to that.
Amendment process is resulting in folks with apparent partisan bias being appointed or ending up administering a trial against such a target. Would that be such evidence?
I think that's a little bit of a conclusory question there, but certainly the process for determining judicial selections, appointments, I think that's something legitimately looked at.
How about contriving jury instructions or administering a trial to deny the target fundamental fairness and due process, anticipating that correction of that would be delayed until after the political impact has run its course in an election? Would that be evidence that Congress should be concerned about?
I think that's more a issue for appeal of the particular conviction. Again, respectfully, I feel there's a little bit of a conclusory aspect.
So you think so long as the appeal will eventually set things right?
So there you see just how much the question really is extremely leading in the sense of he's using all sorts of pejorative language in it. And again, you'll notice he doesn't like me disagreeing with that at all. And then eventually at the end of that clip, he runs out of time and he says just to yield his time, meaning it goes back to the chairman, Jim Jordan, to move on to somebody else to ask the questions. So that gives you a little sense of the flavor of how that kind of hearing goes. And when you watch other congressional hearings, you get a better sense of what everyone is doing in terms of the time clock and what the witnesses are trying to do. Now, the other witnesses, I was kind of the only Democratic witness. They had three witnesses for the Republican side, which is in part because it's a Republican-controlled committee. It's Jim Jordan's subcommittee of the House Judiciary Committee, which he chairs. So I think of note of the other witnesses, one of them was a New York State judge, Judge Wilson. Now, the point of the Select Subcommittee is to claim and add to this fiction about how the Biden administration has been weaponizing the government, weirdly, according to them, having state DAs attack the former president as well as DOJ. Obviously, the Biden administration does not control state DAs. But they've been really focusing on the Manhattan District Attorney's case because Trump was convicted of the 34 felony counts for falsifying his payments to the actor-director Stormy Daniels. So they were actually trying to subpoena the Manhattan DA himself, Alvin Bragg, but Bragg appropriately won't talk to them until after the sentencing. They probably would have liked to have him talk to him during the trial, which was really ridiculous interference. So they had a judge, a former New York State judge, Judge Wilson, to give his opinion on various errors in the trial. And most importantly, how Wilson himself wanted to say that Judge Merchan should never have heard the case at all. They should have recused himself. But I thought it was kind of interesting, their choice of judges here. So I'll take a listen to Judge Wilson for a second.
2004, I served as an assistant district attorney in Bronx County and as a criminal defense attorney. Although I never tried a felony case as a judge, I tried a number of felony cases as defense counsel.
So I was sitting next to him when he said that, and I was kind of stunned. I mean, he has a lot of experience as a lawyer, certainly, but is a judge who never tried a felony? I mean, that seemed really odd to me. That he only had misdemeanor experience and had never presided over a felony, which to me really undercut, how much weight you want to give his perspective on the case. The next witness I want to focus on was Bradley Smith. And Professor Smith is an expert in the area of campaign finance law. And it's kind of a funny story to Smith, at least funny to me. Trump's team wanted to call him as a witness in the case, but they couldn't decide, should he be a fact witness or an expert witness? And so you have to pre-litigate those things. You don't just throw the person on and everyone fights about it. So when they floated the idea of him, they first have what's called kind of a witness voir dire. They'll also present what the testimony will be, and they have to qualify him as an expert if he's going to end up testifying as an expert. So what happened here was that the judge said he can't testify as an expert witness if he's going to opine on the ultimate conclusion. So you can't put on an expert in, let's say, forensic science who gets up there and says to the jury, and I conclude that the defendant didn't do it. Okay, that's because the ultimate question in the case. That's really up to the jury. A forensic expert can talk about things like, this is how you analyze DNA, this is how you analyze blood spatter evidence, etc. But they're not allowed to say, because of that, I think he's innocent, or because of that, I think he's guilty. So Judge Merchan was saying you can't have Bradley Smith, who's an expert on campaign finance law, to get up there and testify that, oh, there was no campaign finance law violation, therefore, of course, you should not be convicting Trump. The other way he could have testified was as a fact witness, but the judge correctly pointed out he cannot testify as a fact witness because he knows nothing about the facts in the case. He had no personal knowledge of it. So Smith was in a little bit of a box with those restrictions on him, but still they could have called him because the judge said he can testify on general matters about campaign finance law, the purpose of the FEC, the Federal Election Commission, and can talk about definitions in campaign finance law. If you recall, that was particularly important because one of the purposes of the falsification under the DA's theory of the case was they were falsifying these records pretending they were legal payments because they didn't want to reveal the fact that they're actually money paid to keep Stormy Daniels silent, because if she talked, that would be bad for his campaign. That's how the campaign finance issue comes into the case. But take a listen to what Bradley Smith finally got to testify about to Jim Jordan's committee.
Explain at length why the convictions of Donald Trump in New York and May, because they relied in the end on alleged violations of Federal Election Campaign Act, or FECA, were incorrect as a matter of law. And I discussed some of the errors of law made by prosecutors and judges in the case. To quickly summarize, the payments that were made to Stormy Daniels were not under current law and should not be, as a matter of policy, treated as campaign expenditures, and thus Michael Cohen's brief fronting of the money, which was repaid to him shortly thereafter, does not constitute an illegal contribution. But moreover, the prosecution theory that the defendant Trump had to engage in a vast conspiracy because of a desperate desire to hide Stormy Daniels' allegations from the public and thus ignore campaign finance laws simply makes no sense, because even had they treated these as campaign expenditures, which again, I think they're correct not to do so, nothing would have come out before the election. As I explained, under the reporting schedules, nothing would have been reported until after the election. And the idea that illegality was needed is simply laughable.
So when you listen to that, you can really see why his testimony was excluded, because he really just wanted to tell the jury how to decide the case. So that was my experience being in the heart of Republican extremism land with Jim Jordan's committee. And it was kind of fun to see them in action. I mean, some of the other folks I got to see was, Matt Gaetz asking some questions. And Gaetz, I'll just tell you a funny story about it, had this sort of anecdotal thing about how he doesn't like to wear ties. And his point was, well, under this type of case result, if it was supposed to be a campaign contribution, then he should start basically buying a bunch of ties and using campaign funds to do that. It was a kind of a silly anecdote, and even the witness didn't go along with it too well. But this was what was interesting. Jim Jordan was just laughing it up while Gaetz was doing that. And it really just struck me as a great example of just how performative and non-substantive this whole exercise was. And again, it's not the Biden administration or the Democrats who are trying to weaponize the federal government. It is the Republicans. And this really is a great example of how they're really not doing anything substantive. I mean, it's just a performance at this point. So that's it for now. I just wanted to share that with you. And thank you very much again for the comments and replies. Keep them coming because it really helps me to hear your feedback and to help decide what else to cover. Talk to you soon.
Love this video? Make sure you stay up to date on the latest breaking news and all things Midas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.